Nambere gukora tukimagambia ukimbera gaterere especially ugakora umete manyata mwono sinyore kuvana atia. Alright, okugukora ugitwereithia mitambore mivotani ya EMBU FM 107.9 noti mugwanja kenda ithathatu kenda igire ithathatu imwe ithatu noti na noti imwe noti inya mugwanja igire ithano inyanya ithano icio nicio namba iria urakorwo ukinginyira nacio yo kathina mbere gukorwo ukimbetanya kio wandwiga mitambo re mivotani ya EMBU FM 107.9 tukauga guku ni gwetu muvango ni wa hustles yetu na kavindari gaka muthikiriria umbetikire tunguririkani Uvoro wigi Kirimara Opticals Limited ngakuririkani Uvoro wigi Kirimara Opticals Limited ngwiraga aya ni the people who care for your eyes na ngakuririkani wega maina computerized eye checkup muthikiriria wakwa maina computerized eye checkup vare marakuroria metho maku wega magatigirira ni mona thina ucio urakuthumbura wega na magatigirira ni magotiriti wega wavo maina duka la miwani vare marakwenderia miwani kwa bei nafuu na maina special offer. Alright, maratigirira ni makwenderia miwani kwa bei nafuu na maina special offer. Okay, na niguo ni tondo metal frames marakwenderia na kuma siringi magana matandatu ma 90 tu peke yake. Specs for reading magakwenderia na kuma siringi magana mairi ma 99 maina blue cut clear and photo specs maina designer frames maina Varilax anti glare photochromatic blue block sawa na kwiaria onde maragura miwani na njira ya cash ugakorwo kinengererwa 10% of the discount 10% discount on the total cash that you have used kugura specs sawa nanga kwera wega tabega condition cia insurance na smart card cionthe nimbitikire kumuthikiriria maruguraga kuma Jumatatu nginya Jumamosi varia Jumatatu kuthie Jumaa maruguraga kuma thaa 2:30 cia kirauko nginya thinasara cia kivwai wavo Jumamosi makarugura kuma thaa 2:30 cia kirauko nginyagia thaa 10 cia muthenya no ati mithenya riyo yonthe wavuga tagatiri ugakorwo kwina break ya ranji ya kuma thaa 7 nginyagia thaa 8 cia muthenya sawa maigukuguo EMBU town kuvario Govio House Kenyatta Road vugo Govio House ruterererwa Kenyatta Road na niguo gukorwo kimanyitithia na njira ya thimu no korwo kimavurira na noti mugwanja noti nyanya noti thathatu inya noti thathatu igiri ngacokera warengi ni noti mugwanja noti nyanya noti thathatu inya noti thathatu igiri wana kana noti mugwanja ithatu inya ithatu noti igiri ithathatu ithano noti mugwanja ithatu inya ithatu noti igire ithathatu ithano tugakorwo tugitwarana wega na nguririkania atiriri mamiene tiganite ya vururi mamiene tiganite ya vururi tuambe tuthikiririe kaundu kaya voguo nigetha vote kuelewa kuria mari muthikiriria wako.
Je, una matatizo ya macho au ungependa kukarabati miwani yako? Basi tembelea Kirimara Opticals iliyoko Mbuni House opposite Nokras Hotel au Kirimara Opticals iliyo katika barabara kuu ya Kubukubu Wanjiru Center next to 7 Sunday. Kumbuka, Kirimara Opticals wana miwani ya aina mbalimbali ikiwemo CC Boy, Guess Bavino, MCAT, Eden, Katia, Ripple, Varicose, Photochromic Plastic NAR, Blue Cut Lenses, Bifocal Glass and Plastic na normal glasses. Kirimara Opticals wapo Meru Njuri Cheke Street next to Family Bank, Isiolo Town wapo 101 Plaza next to Silverwells Hotel, na Nyuki wapo Oasis Plaza shop number 5 Lumumba Road. Nyeri Town wapo off Gakere Road next to Naivas Supermarket. Kirimara Opticals Limited tunakubali malipo ya smart cards na bima zote. Kwa maelezo zaidi wasiliana na Kirimara Opticals Limited kupitia nambari 0708064062 au 0722939379 au barua pepe kirimaraopticalslimited@yahoo.com. Kirimara Opticals Limited, 25 years of optical services in Mount Kenya region since 1999.
EMBU FM 107.9 huku ni wetu.
Mnyakio wanduiga
Semanyona gadino kapako gedo Chenyenera morunga ya kandadima Kore mora tokore agamwe hamwe No mide koine ya kengo na kero Kore mora tokore agamwe hamwe No mide koine ya kengo na kero Kiwara tanie kiana nyoni oro Siguwa garatanie ke didi moko Kiwara tanie kiana nyoni oro Siguwa garata tuere karo ama
Existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The council representing the County Assembly will be here shortly to try and convince you that what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a house proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025 and proceedings that are said to have taken place on 26th of June 2025. Honorable Senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards. And this being a house that is also a house that is very much familiar with proceedings in the house, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7 of 7 of volume 3 of the documents. Page 7. We see the House purportedly sitting for the first time. There is no communication from the chair. There is no calling of orders by the clerk. Straight away, the mover of the motion proceeds to execute the business of the day. Look at it. It is straight away withdrawal of the motion on the impeachment of Isiolo County Government dated 10th June 2025. What does it begin with? Honorable Abubakar Godana. Honorable Senators, who presided over this session? There is no invitation from the Speaker for the mover of the motion to proceed and execute the business of the day. Let's proceed. Honorable Abubakar Godana proceeds and proposes a motion to withdraw the previous motion and invites two members of the County Assembly, Honorable Nicholas Lorot and David Nyoro, to second the motion. Without again the intervention of the Speaker, these two members rise and they proceed to second the motion. So who invites them to the floor? Who is presiding over this House? Let's go on. The two members support the withdrawal of the motion, and the Speaker now is seen for the very first time. There is no question put to the members. There is no vote that has taken place, but the Speaker proceeds to say, the members, the notice of the special motion or the removal from office by impeachment, the Governor of Isiolo County issued on Tuesday 10th June 2025 has been officially removed as requested by the mover, Honorable Bakar, member for Sericho Ward. We now proceed to the next business. So who approved this withdrawal? Who approved this withdrawal? Where is the vote? Let's proceed. Honorable Senators, we proceed to the Hansards now. Is being purportedly impeached.
Kundu gwitwa Mwea launch ya gukasmato nigetha tukavota kuviririkia rwimbo ku wota mutomunie nawe muthikiriria tuvatie tutumene ciringi 200 tu mathe magukorwo tugikinya kuri uguo Mwea nigetha tukavote gukorwo tukigemereria kiathi kiomo wacie tugwitwo gukasmato kogwo wewe vau uguo wokirangite ta imagine soso agituma mbere yaku mundu gwitwa wanjira soso no soso atumete mbere yaku what's up mundu gwitwa njaki wa kivote no raririkana ngo tariki kivao ni cie kuri uguo kuri kwa tariki kivao mweri uyu ni cia kuthie kuri uguo kwa gukasmato na naugira by the way ngaigirwo kamocere gukasmato agakora no urambigwa nake Saimo tondu ni medete napenda samaki sana koguo Saimo kambigira katilapia nigetha ngavota gukorwo ngicira kana wewe ri ukoneka we bora ni samaki bora ni samaki were akoneka ngaigero nega korwo fresh nigetha ngavota gukorwo ngiuka ngisagira sawa sawa. In the meantime ni nirakwirira ni Uvoro vathi karinda gakwa ru natigaria gugagekira video nigetha ngakorwo ngikaviririkia vizuri kavinda gakogwo ngenda gukuririkania Uvoro wigie Pema Driving School and Computer College kwa Pema Driving School and Computer College muthikiriria ino ni sukuru nererathi na mbere gukorwo gikuthomithia kosi ya utereva wavo magakora maina computer classes vera marakuthomithia computer packages na mweri umwe na rio magakora maina school of music vera marakuthomithia kuthaka piano guitar na drum set sawa akogwo gekinya thogwo no vote gukorwo kithoma kosi ya utereva gwatamakiria kosi ya plant operator. It is just the other day marakorirwo magikatia launch plant operator kogwo gakorwo kithivu interested no vote gukorwo kithoma vataina kizuizi chochote sawa ni tondo mathomo mao ni magikiro kia neguru ni tondo ni mavitukie kana maratongorua ni the new curriculum ya NTSA kogwo muthikiriria mbugite ogwo ukere wate mathomo ma mchezo rakurwo kinengererwa vo maimiene tiganite ya bururi Nairobi matu mwingi wa ithaka cia kagoi ciara kanyua mbora marimanti makutano kate kiritiri na wana goko town ile ya Embu maikuo sawa kogwo ugakorwo kithie na mbere na gukorwo kimacerera nigetha uvote gukorwo kigira kosi na ungenda gukorwo kiaraniria naona njira ya thimu ndu wande to makiria no uvote gukorwo kimakinyira kuvetukirira noti 7 2 3 8 6 8 7 3 9 noti 7 2 3 8 6 8 7 3 9 wanakana noti 7 3 1 2 3 inyanya ithano igiri noti 7 3 1 2 3 inyanya ithano igiri ngathi na mbere gukorwo ngikwereithia kuri ugo Pema Driving School ikinyie kuo thome utereva nigetha no ukigura ngari ndugakorwo ukigura ngari utaici gutwara nawe muthikiriria wakwa no vati gukorwo gikatia uici gukorwo kimiruta kana atia ngona sivandite wega thaa 5 na ndagika 46 tugakorwo tuthiite na mbere wega na ngakwira wega ta wega uthie na mbere gukorwo gituliza gwaku mucii wina thayo ni tondu we tiko kene gukugwo muciri munene wa Embu kuona thaino guo ni mungethaniro gatagati ka mavitha avurithi na rurungani aria maratetera mumbunge wa gicigo mbunge kia Manyata akorwa agikatia kithie na mbere na gukorwa akirekererwo kuona nurakorirwa kiamato ni mavitha vorithi muthenya wa iguru ngwirire gitumi ningukorwa ngikunengereria kio wari kana mundu gwetwo Stacey Academy athi na mbere gukorwa agikuthagathagera ni akuvota gukorwa agikati agiuka nigetha vote gukorwa agikumenyithia mengi ndeto ino irekeka no twariki gukorwa tukiaraniria na mundu gwetwo Kanu wa Cavalry agitwira wana kuria Manyata town njira ya kuthie kianjo koma na njira ingi ndararirikana niriko no wavota gukorwa agitwereithie kuo ni tairi mundie mwaki kogwo we muthikiriria wakwa we uregwa takota angikorwa we safe tafadhali ikatirire muthikiriria ai ikara kurio gugugwitwa nyomba fata kutuvotana na kimbi sawa ungikorwa nawe ravangite karugendo agakuma gaguka guku go town ile ya Embu kana ungivitukirira guku town ile ya Embu muthikiriria wakwa ambo gatirie tugaga muthenya tumwe na wakorwo gigatirio kathie rucio kwega kwamba kuvorera uguo niguo kuvati gukorwo gwikite atia akuvana sawa tugakorwa tuthiite na mbere wega gukugu mitambo ni mivotani ya EMBU FM guku uku nikuo wetu. Sawa sawa.
Munyakio Wandoiga.
Learned Council had told you was invited to appear at 9 and we at 2 o'clock. The speaker is not seen anywhere saying that we invited the governor by this letter and he has not come, but instead asked the clerk to check whether the governor is available anywhere. Let's proceed. I'm completing, honorable senators, and this is going to shock you. So, when the governor was confirmed was not in the house, the speaker proceeds to guide the house on the next move. At the end of that page, 41, I read what the speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the speaker shall, this is the speaker telling them, the speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors Through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are two subtitles at page 60 of that manual, which is subtitle 1, comply with court orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is participate actively in court proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist. Because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly, before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, Despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I'll then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I am always impressed by the support we get from the administrative teams in this Senate that may have to go on record in the interest of posterity.
Okinailyone, Bethesda Medicare Institute. Bethesda Medicare Institute ni cukuru mbitukie ni thirikari ya kuthomithia amenyereri kana caregivers kwa uvoro makeria araniria nao kuvitukira namba kivugo 7 kivugo ithano igiri kivugo igiri 15 070052.
Muthikiriria sievandite thaa thita na mama ni matemo ma movoro ma EMBU FM 107.9 retora kwa Stacy Karemi. Mbunge wa Manyata ke John Gitonga Mukunji ni wakorwa agikinywa igotiriria kahawa mwena wa Nairobi vuva wa kuruto gitwere kya borithi kya Muthaiga kuria aravingiritwe.
But without getting Benet from South Africa, pursuant to the extradition treaty, are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at Rome. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum.
Muthikiriria iyo ni cira ya mumbunge wa Manyata John Gitonga Mukunji iria irathi na mbere igotiri ria kahawa Low Court mwena wa Nairobi. Atukithi na mbere ni ati nduka nene ya Magunas county ya Meru ni rakorirwe ikimundwa mwaki muthenya wa igoro mururungano uri wa Sabasaba guku andu aire makioragwa na mwana umwe wa miaka 7 akirathwa uthukangia munene na guo nura korirwe ukioneka.
Muthikiriria na tukithii na mbere ni ati mururungano no urathii na mbere tauni ya Embu muthenya wa umuthi guku ekari makiendekithia kurekererwa kwa mumbunge wa Manyata nike John Gitonga Mukunji o ni vuvao wa kunyitwa muthenya wegoro agikuruvanwa na gutongoria mirurungano iria irathii na mbere guku bururi-ri. Muthikiriria tukora tugikinyia vau matemo ma thaa thita rĩtwa rĩakwa nĩ Stacy Karemi.
Na mau marare matemo ma EMBU FM ukimenyithio ni Bethesda Medicare Institute. Bethesda Medicare Institute ni cukuru mbetokie ni thirikari ya kuthomithia amenyereri kana caregivers kwa uvoro makiria Ready moko bitokera namba kivogo mugwanja kivogo ithano igere
and will do its duty to protect the fundamental rights of Kenyans. Your beloved colleague Senior Wamalwa is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. And a contrary action
by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding.
What that compliance
null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by...
So there is a contempt against this court in presenting these accused persons before you to stand trial over a matter that the prosecution chooses. We shall not go to the High Court, we shall instead take people to power. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to power. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in case now. No. Your Honor, the second part of these orders from Kahawa were this. The prosecution was beseeching those courts to complete investigations. That's why they needed the detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by 36A and 36A of the CPC. For facts, as far as this matter is concerned, this is Friday. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution that is the subject matter of the ruling of 4th of July is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can have them every other day, twice a week, to complete. Nevertheless, here, because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were made, only the High Court could validate that position. That if you wanted, you are dissatisfied with what those magistrates say, you needed to go and convince a judge of the High Court. Now these are such dangerous people that your learned colleagues at Royal and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Ruiru and Kiambu got it wrong, get another interpretation of the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And you know, we cannot have. So that you honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Secondly, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Yes, there is a proviso that is made that that is Section 2 actually, that with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary. Because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included. That we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Your Honor, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity waged by Kenyan citizens across Kenya, there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism, everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. You know, the related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. Your Honor, this is absolutely important for a very simple reason. Your Honor, for purposes of the trial, it must be done in an open court. Your Honor, the trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. My Lord, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about 4 facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa we deal with terrorists. If for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution exists. You know, at that point I make it with regard to 2 last issues that I'm about to make. Sections 42A of the CPC, Sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Preventions of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Preventions of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we break, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42. Sorry, we were dealing with 36A the other side. Yona, what is it about this section? Yona, what this section is based on is because those specified and to national security, that despite Article 50 of the Constitution, to prosecute the case without availing of the that is an absolutely important issue. Because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist, you
nikomete horerete we ugathukiria mudi kai wendaga tendagerie no kotare mutwe mwega ni watuire na itwa ndire hende ngamenya kiugo thayo koro wina kiongo kana mutwe mwega tarenga thimwe thayo wakotana uharagania waruta hinyako wamenyare muisho wanjekanirie nduraga njorotagwo ni andu Nietagenge wa mutere nayo no wa mutere. Tina weka uru no wewe wa mutere original. Kamage nawe ne kongushagia thakame wana tangi. Ike kuremera ngogethere na ngonyute kombe. Koro wina kiongo kana mutwe mwega. Tarenga thimwe othayo wakotana uharagania. Waruta hinyako wamenya ria muisho. Ria wanjekanirie ndoraga njorota gone ando. Wagi wa Augusta superstar sana Motu Diena gatandare sa honge konya defo ya koyode. Umbe wari duera otoria tuira nagia nani. Nane mawe kiongo kio monge korondo makagio neni. Onago kamondo ndoe inyo korago mahindene. Korowe na kiongo kana mutwe mwega. Tarenga thimwe othayo wakotana uharagania. Waruta hinyako wamenya ria muisho. Ria wanjekanirie ndoraga njorota gone ando. Dama wa mobile spares. Nyegire shuwa otoria shuwaga na niuria wenda. Ateo waona werurukanagia na ritwa riakwa. Ohana kenyoro keruta gogageta murithia thi. No unyitereire romia thimbo ngoe giki kia muisho. Koro wina kiongo kana mutwe mwega. Tarenga thimwe othayo wakotana uharagania. Waruta hinyako wamenya ria muisho. Ria wanjekanirie ndoraga njorota gone ando. Ediwito kazini Team Loyal Family. Washabiki wangu sana Karis Afro Country Waina wa Afro Country Studios. Thank you daddy. Joy wa Masharia
Nyakio Wanduiga
EMBU FM 107.9 huku Negwetu.
I want to argue only one point of fact. I want you to look at that sheet for Sarah Wanjiku, Itiga, and the Peter Kinyanjui. Look at the stamping, just page one. Who playing it? It says, office of the DPP just received the judge. The honor the law as the power to formulate judges. Look at the face value of the judge. The judge, if you look at it at the top at the bottom. It says received. Look at that received. The DPP just received. It did not exercise its constitutional powers as contemplated by Article 157, Clause 6B, to formulate the charges or terminate. Is being used as a rubber stamp. The DPP has become mechanical, and yet the DPP should be the driver and the champion of this process. So, Your Honor, look at the left side of that charge sheet. Look at the left side of that charge sheet. It is written PP. Your Honor, just let us interrogate that one. PP. Who is PP? People are known by their names. People are known by their names. So we don't want these jobs. We want people to take responsibility. If a prosecutor is signing a charge sheet, the condition is name and the rank of the prosecutor. On that ground alone, we don't need to be academic. This is not rocket science. On that ground alone of that charge sheet, the face of it, AA and PP. We don't know who AA is. So he cannot be held into account. So that if there is a problem, we can pursue him in civil proceedings to recover damages. So we don't know who AA is, and I know I have tremendous respect for the DPP because my wife has worked as a DPP, so I have tremendous respect. So I'm saying this from the bottom of my heart that they need to be accountable, and that's what we are demanding. Yes. Yes, Your Honor, for that, I think I've added some time.
Your Honor, from the law side of Kenya, allow me to start by saying that we need to adopt our submissions, especially the points of law in regards to the propriety of the charges facing the subjects before the court in totality, so that we save on time. In fact, for the record, the submissions are in reference to E68 of 2025. Yes. Your Honor, the first is our submission is in reference to the files that we just brought before. I'm adopting, yes. Your Honor, the persons before you are currently enjoying orders of this court in reference to their liberty. This is a person to miscellaneous criminal application E290 of 2025, the Chief Magistrate Court of Kiambu, for purposes of record. By the two. One is arson, contrary to section 332 of the Penal Code. The second one is malicious damage to property. Of the Penal Code. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice on the public document. All I am trying to say in the interest of time is that the offences that the persons before you had allegedly been brought before the Kiambu court on a miscellaneous ground. And I am not in any way saying that offences related to water are not serious. But the ones I have cited carry mandatory sentences that are extremely punitive. Your colleagues in Kiambu agreed in those offences with the respondents and afforded them bail terms. am reading the National Police Service Standing Orders at chapter 15. This is at section 2 on detention of arrested persons. Section 2(2)(d). The import of this section, Your Honor, is to guarantee the enjoyment of the fundamental right to bail and bond of a person by a police officer. What the masked and hooded men and women wearing the Kenyan National Police Service insignia, who whisked away the two, failed to appreciate on that day is that the law was not on their side. Before arresting such a person, they ought to have made an apprehension report in section 37 of the CPC to yourself or any other magistrate within the definition of the Chief Magistrate's Act. To have the person remanded. That was not done. Your Honor, in Law Society of Kenya and 5 others, I am buttressing what Mr. Ibe was saying. In Law Society of Kenya and 5 others versus Kithinji and 5 others. This is a constitutional petition E. Your elder brother, Justice Momuye, your elder brother, 373 of 2024. A vehicle that they use while in airport.
keriroka no endo waku ratha makagoro oi no endo waku ratha makagoro Siawa mariro boigo ikeriroka no endo waku ratha makagoro oi no endo waku ratha makagoro wewe nyoko ya jeli itheria masenogari no mwere no turathie sapa China
There is need for this court to address that. To be charged in Garissa or Mombasa. So that kind of nomadism need to be discussed. another room was arranged for that. So, Your Honor, I did it. Right? Your Honor. Maybe you should clarify. The case numbers for which the accused person was charged. Whenever the DPP stands with their feet or adrenal in line. And you are concluding. So I was at the tail end. Thank you.
A tear gas can was thrown in the cell. When he was held in an office.
Only 1 minute, Your Honor.
Yes, one
Just
minute.
the circumstances of that shooting and killing were as they were on the 25th of June. That was 30th of May, sorry. But that's during the demonstration for Albert Ojwang. But that officer was not brought before any anti-terrorism court. Yet the circumstances fits and suits the definitions under Section 2 of the Terrorism Act. It tells you there is a double standard in the manner in which the DPP is executing its functions. Finally, in summary, the doctrine of exemption created by Section 2, which our land senior counsel, His Excellency Dr. Kalonzo, referred to, exempting protests from acts of terrorism underscores the necessity of distinguishing between peaceful expressions and violent acts. thereby upholding democratic principles and protecting therefore would mean that the church is stinking to the high heavens and that this
our forum from the West Side has increased. We have Mr. Brian Bashir.
Thank you, Your Honor. Listening to submissions by the defense and before proceeding to make submissions, I'd like to highlight, I think, one issue that has become content in these matters. Peter Kinyanjui and Sarah Wanjiku before this court are facing provides an exception under Article 37. That was on what we do not agree with them is the act and notices had been the act goes on and says within the meaning of this definition, as long as the act, now this is the part that the court should look at. In our charge sheet, we are saying that the harm is not intended to resort to any harms referred as to paragraph A1. You will see that any act that happens under the said provisions is exempted from a peaceful, protected protest. Now the act of terrorism, in a very plain understanding, or breaking it down to everyone to understand, it only transits to act once you cross the line under Article 37. The Article 37 is protected, and you are acting, and the demonstration started under Article 37. They crossed that line, and their action resorted to paragraph A 1 to 4. Then terrorism charges began. Terrorism acts began. And from the word go, counsel for the defense was submitting from the bar. You've been given nothing. Nothing to show that indeed there were abductions.
Your I think this is something in the public domain that you
What I was saying before was disrupted. An abduction is a legal term. That was taken by the defense in support of an allegation that there was an abduction that transpired. When the two on section 37 of the CPC, but allow me to take you back to section 21 so that we can move. Section 21 gives the police the power to arrest, and the arrest at touching. Once you are touched, and then it goes up to confinement. From confinement, then it gets to all means necessary. And from necessary, and this depends with the reaction of the person being arrested. The law says that no greater force than necessary may be exercised. So there was an escalation from touch, but there was no all excess force that was used that was necessary, and that is our submission. And if indeed there was, now that becomes subject to trial. The defense or people alleging that more force than necessary were used, then the burden shifts to them to prove that indeed more force used than was necessary. So abduction, we submit, is a legal term that has legal interpretation, and what transpired is not an abduction, but an arrest. They've equally, submitted that there were other charges that were facing the two accused persons before this court. With all due respect to counsel, there are no charges that were before any other court in the Republic of Kenya. What they are quoting to you for custodial orders, pending charging, and that is why they've not presented any charge sheets before this court, because indeed there was none. If they are candid enough, they would admit that what was there was a miscellaneous application. And after a decision was made, to declare that as at that time, a decision was made to charge with terrorism, and they were therefore now transferred from try terrorism from any part of this country. And the charges before you, Your Honor, brings the accused person at the scope of this court. Let me go to section 36, Your Honor, of the same CPC. It provides for detention, gives the police the power to detain people arrested without warrants. Your Honor, section 36 provides for detention of persons arrested without warrant. Immediately after section 36, you've been told about section 37, that they are supposed to report their apprehension to a magistrate. You see the selective reading of the law. Of the OCS of the police station have, the responsibility to report that apprehension to the nearest court, Your Honor. And on 4th of July 2025, of the arrest, which was on Friday, past working hours. The Constitution says that this apprehension and if the 24 hours falls outside the working hours, then they are taken before the court at the end, before the end of the next court sitting day. Hours. On Monday, the 7th of July, they were arraigned before this court, and the court was informed of the arrest and the matter after arraignment. There is no impropriety, illegality, or abduction. Consequently, from the arguments of section 36, 37, and the Constitution, other that having been said, Your Honor, the two individuals before this court, you're told that they are party leaders. We are not here because they are party leaders, Your Honor. We are here because a charge has been approved, and the jurisdiction of terrorism charges can say that they are being profiled before a court that is not sufficiently equipped to give that decision, since the decision, the ODPP decision to charge at a portal. Your Honor, in legal terms, what they are telling you is, can their decision be reviewed judicially? And if that is so, if that is what they're asking, Your Honor, the court that is equipped to deal
and to check any excesses in terms of whether the decision was appropriate or not is the High Court on judicial review. Therefore, any argument as to whether plea will be taken or not, Your Honor, whether the charges are appropriate or not, cannot be legally and sufficiently be heard of before this court. And a decision to charge having been made, then the plea, the most appropriate lesson to take is to allow Your Honor the plea to be taken. The remedy under judicial review does not subsist the plea taking until the trial is completed. Your Honor, there are some few issues that have been raised about Upeni nyote nyinyi nyote such sentiments, Your Honor. And unfortunately these are sentiments for the defense. We do not know whether they intend to swear any affidavit to that effect, since information from the bar is a legal force of law unless it's submission. That information has to be communicated in a format known as an affidavit and not through hearsay from the true defense counsel, but by the person who was addressed. And I'm very concerned that counsel can submit as such. If indeed there was a police officer who did that, let them follow the right channels so that we can learn from politics. Finally, as I sit down, legally, Your Honor, there is nothing presented by the defense, whether constitutionally or through submission, that has raised reasonable grounds, Your Honor, to stop plea taking. The issue as to whether these are the appropriate charges or other appropriate charges should be preferred, Your Honor, is not an issue that can bar plea taking. And we wish the court to find that the charges are before this court. These people have been registered appropriately within 24 hours and plea will be taken, Your Honor. I have two colleagues, Your Honor.
Your Honor, just to buttress the point of my senior colleague, and I will submit on the issues in the application that is being made by my senior counsel, Mr. Kibe, on the issues of whether the rights of the arrested persons were infringed when they were being arrested. Your Honor, these issues would have been raised under Article 89 of the Constitution. And so, counsel should be telling you that his clients were denied counsel, or they were not brought before this court within the 24 hours rule as stipulated by the Constitution, or they were denied counsel, or other issues that are outlined in Article 49 of the Constitution. Those are not issues that have been brought before you. And if they were to be brought before you, or as counsel has said that they were abducted and not arrested, this court, then the question should be, can those answers be answered? But can those questions be answered by this court? And I say, interpretation of law, especially with regards to breach of rights, fundamental rights under the Constitution, can only be interpreted by the High Court. You look at Article 165, the Constitution, sub-article, that is B, it speaks to the jurisdiction of the High Court and says jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. This to say, this court has no jurisdiction to entertain the application by counsel to determine a question of infringement of the rights of the arrested persons. And why are we saying so? Because when counsel alleges these matters from the bar, are we allowed to cross-examine him? Because these are issues that he brings from the bar. Can we put him on the dock to cross-examine him? So this question is a question of trial, requires evidence, requires affidavits, requires to ask to be given an opportunity to respond, because now the blame is on the police officers who are allegedly abducted these individuals. Therefore, Your Honor, we are just saying simply, the issues that are before you are very simple, and they have very, very simple answers. That one, on the issue of whether the charges are proper, we have already submitted, and our position is, yes, they are properly brought before this court. And on the issues of whether the accused persons are properly presented before you, those are issues that cannot be litigated here. They have a recourse elsewhere. The accused persons are before you, and they are properly presented before you, and we have supplied them with the charge sheet. And Your Honor, you should allow us, this court should allow us to proceed and the accused person take plea.
Your Honor, I wish to adopt the submissions of my senior and my colleague. I believe we have given sufficient grounds as to why we are charging with these counts, with these charges, Your Honor. We also submit that this is the proper, we use the proper channel, this is the proper court to present these charges. We do acknowledge Article 37, and we do respect it, Your Honor. The issue at hand is whether there was a commission of a terrorist act. We wish for the court to look at section 2A(1) to 4 of Prevention of Terrorism Act, which provides to when a protest, to what actions can lead to a protest being regarded as a commission of a terrorist act. From the particulars, it's quite clear, we've articulated all of them. There was destruction of property and among other issues. We submit that the charges are proper. The elements of the charge have been articulated in the particulars of the offense. We say that you do allow us to proceed in plea taking, and the issues of evidence can be dealt with later, where we can be able to show that we were able to use the decision to charge guidelines to make these decisions.
Your Honor, before I seek to defense, I would also wish to raise a concern. You know, as we are proceeding and making legal arguments before this court, one of the defense counsel, Mr. Ndegwanjiru, advocate, in his Twitter handle, @Jiro Advocate, was busy texting our names on social media and generating a debate, and the title, Your Honor, of the same Twitter is weaponization at its best. he proceeds to say that 3 council appearing for the state are weaponizing this process. You know, for me, I take that as an incitement, and I do not take it kindly. And this council should be reprimanded, Your Honor. And it should be one also that should he incite public to generate any reaction, then he should be answerable, and the court should, and the court should take notice of that.
Can we just allow the council?
Yes. And you know, this is a post that was done at 11:12.
You know, my required to respond.
And also amended and reposted again.
Yes, Your Honor, I do not believe that those are issues under the trial. Yes, I did it in exercise of my rights. Council stated their names in the glare of the public and the media. And if I am right, Your Honor, I would wish to restate the said names so that the record may read correctly. Yes, I think we are dealing with Ms. Wangui, Ms. Mashira, and Mr. Kamau as the council appealing for the BPP. If I am wrong, Your Honor, then you can correct the record so that I can edit my tweet.
What about weaponization? Just read the entire Twitter.
Yes, it's not an interpretation. You can bring an affidavit and respond to it appropriately.
You're not from the Law Society. From the Law Society, this is maybe an issue that they can deal with internally in the Law Society. Council for DPP has alleged severally that you don't have jurisdiction on everything. Probably is doing this. We can deal with it from an NSA so that we move on. And it's something that can be resolved. I hear you, Council. Mr. Kabata. Yes.
Now, I do agree that the statements that have been made by Council have been brought to the court's attention. And Mr. Bashir, you highlighted them. I think not for the court to take any particular action against this individual, but the court to note that that has been done. And that therefore, Mr. Bashir, you have a statement which is a platform, and for what that is worth, you will know how to pursue that.
Most of it.
Just to say that again, that we the court makes a determination on this. Why don't we allow the process to run its course? Thank you. So that
Absolutely.
Yes. Your Honor, I wish to agree with my learned counsel from the DPP that the term abduction is a legal term that ought to be used in the technical sense that it means, and particularly for purposes of judicial proceedings. Your Honor, articles, no section, Your Honor, under section 250, the word abduction or the offense of abduction is induces any persons to come from any place, is said to abduct that person. Any person who by force compels, that's the first part, or by deceitful means induces any persons to go from any place, abduct that person. That is section 256. In the circumstances of this case, we are relying on the first part, the use of force, which was witnessed during response, used to get them from the courts, and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the other side, the DP, Maura Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail, pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Hospital Roads Magistrates, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, And that order was not there. The court actually said, we cannot allow people to be tried in English courts. People who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Canberra, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. So the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justified the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Hospital versus Magistrate and in the Gedogori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, arson, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge. That has been made by the DPP. There is no doubt that the DPP can make decisions to charge. You must be satisfied that you have jurisdiction. Jurisdiction can be called where there were rules. It clearly cannot. You cannot say that you have a valid charge. Let us wait for the DPP and the police.